I then asked whether or not you had a response to that.
I feel like I'm capable of.
Today's docket erupts immediately as defendants argue over bond restrictions, marriage counseling, and disappearing courtroom behavior. One judge warning hints somebody may cross the line before proceedings even settle down. Every decision here could instantly change lives, freedom, and families forever. Subscribe now for more explosive courtroom breakdowns and drama.
The time frame preliminary examination will be set for April 7th, 2026, 9 a.m. That's before me.
Thank you, Your Honor.
Round continued. Thank you. Do we get the no, he's not back yet. He's refusing.
Yeah, but I don't know.
He was there. He got up and walked off. That's why they shut it. Okay. Well, if we verify that, then I'll recall. The court calls the case People versus Glenn Bradford.
Allie said on behalf of
Assistant Public Defender Jay Bellinger on behalf of Mr. Bradford, who approaches.
Bradford. Well,
And Your Honor, we are seeking an adjournment on this matter for purposes of negotiations, and I would also be asking to address bond. I do understand that he is out of custody.
so this could go south. Okay, no, that's fine.
Always
Fine. I will adjourn it to April 23rd, 2026, 9 a.m. As to bond.
As to bond, Your Honor, my understanding is that this case was initially charged last September, then dismissed, and then at the beginning of March, and then recharged at the end of March. During that intermittent time period, Mr. Bradford and his wife began marriage counseling. My understanding is that she's here today and she has had an opportunity to speak with the victim advocate. My client, Your Honor, would be asking for his GPS tether to be removed as well as for contact to be reinstated. Reasons being, Your Honor, they are doing that marriage counseling. They'd like to continue to do so. And again, my understanding is that she's okay with the no contact being lifted, but I would inquire as to what Ms. Zinda thinks.
Really? You're going to ask?
I don't necessarily want to know the answer, Your Honor.
My role to say, is there a risk? That's okay, Bellinger. You keep wanting to go ahead. There's going to be a line today. He's going to cross it. You're really stamping on it. Ms. Zinda.
So she requested no contact to be removed. She said she was not afraid of Mr. Bradford. And I do understand that they are in marriage counseling, so I will leave it in the discretion.
I will add a provision of no non-consensual contact. I will delete the no contact as well as the no go-to provision. And defendant's GPS tether may be removed.
Thank you very much, Your Honor.
Thank you, Your Honor. You're welcome, sir. I did it for you, not yours.
Okay, so over to community.
Wait, Bellinger, you never lower a bond. I'll pay. Remember that case, Bellinger. Hear me, Bellinger?
I'm so sorry, Your Honor.
When you're up there screaming and yelling about, you never change your bond. You never, for us, never do anything.
When do I remember that?
Remember, do that all the time.
Thank you, Your Honor.
That out there. Court calls the case, People versus Wardell Smith.
Allie said on behalf of
Morning, I'm Rob Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
and Your Honor, your response.
All right, preliminary examination will be set for, will the people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge,
Yeah.
may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
Because I know what she's gonna say, so I want to beat her to the punch.
Okay. Go ahead.
Judge, no, not to be facetious, but my understanding he's got a $50,000, 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000, 10% bond tether if necessary. He's the sole supporter of the family. He will stay away from the marital home as for now and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made, I believe, by the last check was 65 calls to the victims listed, number which we have had contact on correctly before from his pin since being arraigned in the jail. I and for his phone privileges and text privileges to your votes in those calls. There terms of giving I love you, babe, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction of bond on tether.
I'm going to deny the request. He's violating the conditions of his bond, or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue. Defendant's phone privileges and texting privileges are hereby ordered to revoke pending a hearing. Thank you.
Yeah, come and see you.
At the 6-minute mark, Wardell Smith's request for reduced bond completely unravels after prosecutors describe alleged jail calls violating no-contact conditions. Defense attorneys argue reconciliation, family responsibilities, and graduation plans, but the judge sees continued risk instead. Would you lower bond after hearing those conversations and accusations today?
Thank you, Your Honor.
Court calls the case, People versus LaShawn Charles.
Oh, no, good people.
Really? LaShawn Charles?
Good morning,
Good morning. State your name.
LaShawn Charles.
Thank you. We're waiting on your attorney, Bellinger.
Okay.
I'm not going to hear Miss Gaines. Where's Bellinger? Where is he? Where? Gee, oh, Pete, I called this case like hours ago. Oh, I called the case a long time ago, and we've been waiting on you.
So sorry.
No, you're not.
I am.
No.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Charles. Hi, Ms. Charles.
Hello.
It's already stated her name about 55 minutes ago.
Your Honor, this case is currently with Victoria Burton Harris. I have emailed her with regard to a resolution. I'm just waiting on her to get back from her leave. She is back on the 6th, I'm told. So I would just ask for an adjournment past that date. We should have an answer at that
Should
point.
have an answer by then. All right. Probable cause conference will be adjourned to April 16th, 2026, 9 a.m.
Thank you very much.
Bond will continue. Thank you, Ms. Charles, and thank you for your patience in waiting for.
Thank you so much.
Court calls the case, People versus Tyler Watts.
The Assistant Public Defender Natalie Pate with and on behalf of Mr. Watts in the case 25FB1347. And Sherilyn Foster Tucker on behalf of Mr. Watts in the case ending in 1734.
All right. What are we doing? Because I have a plea form in your case.
That is correct, Your Honor. And Your Honor, in my case, I just jumped into this case yesterday, so we were not able to get the paperwork in. I'm just asking for a brief adjournment so we can finalize a plea agreement.
On this case?
It makes sense. I don't.
Go ahead.
Take, work, if we, PD case today, or we can adjourn both, they could be on both. Sure enough.
Is he being held on anything else or?
Yes, Your Honor, he's being held on a violation of probation in circuit court, but Mr. Watts indicated to me he believes he has a release to treatment on it. Oh,
Good, I'm sorry.
but he believes he has a release to treatment on that file.
Okay. I normally wouldn't do this, but I don't know, Ms. Prosecutor, are you, that's a guilty to a misdemeanor of some type? That what it is?
Yes.
And does he wish to do that or, okay, if we can. Okay, I normally wouldn't do this, but if we can get the paperwork in, let's try to take care of it today, get it done. If, unless somebody has an objection to that.
Oh, that's fine.
All right,
No problem with that.
all right, so I'll pass these matters. We'll take you back and we'll get you out here to try to get it done. All right, young man?
All right, thank you.
Oh, another young man. Joe Simon. Huh? Yeah.
Good
Oh,
morning, Your Honor.
good morning, sir. It's a pleasure seeing you.
As well.
Hawthorne said he didn't want to talk to you. He told me that early today.
Well, I can tell you that he never responded to my reach out yesterday.
See, that's what I'm telling you. So why'd you bum rush him like that? All right.
Well, responded just to.
Okay. Oh, all right. I don't want to get into that between you two. I'm done. Court calls the case. People versus Danina Combs.
Right, calling on behalf of Ms. Combs, who hopefully should be on Zoom.
Morning, Mr. Bull. Oh, well.
Awesome.
Yeah, I'm here.
Oh, hold it.
All right.
Hold it. It's a phone call.
Yeah.
Your name?
Danina Combs.
Thank you. Phone in. That's why.
Yeah, great. I'm glad she's here. Your Honor, I spoke to Ms. Combs yesterday. I also had some discussions with Mr. Childers. We're looking at possible resolution options of this matter and or these matters, if you will, and need a little more time.
A little more time. 23rd work for you?
Sure.
All right. Probable cause conference will be adjourned April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case People versus Jason Bryant.
Brian Bowling on behalf of Mr. Bryant.
Simon, put that back. John. Your name, sir?
Man, Jason Bryan, how you doing, sir? Sorry to see you this again.
Oh, why?
Just in this
I'm
context.
just,
Oh, in this way.
yes. I'm just
How are you doing?
not so pleasant.
All right. Let's see what we can do to try to get you through this.
Your Honor, I met with Mr. Bryant at the jail yesterday. We're just asking for an adjournment for some additional plea discussions.
All right. Why don't I just put it out 2 weeks, put it out to the 16th, April 16th, 2026, 9 a.m. Bond continue.
Perfect. Thank
All
you.
right. Thank you.
Around 12 minutes in, the courtroom atmosphere turns uncomfortable when Jason Bryant returns to jail for more plea discussions before Orby Huffman insists on representing himself against felony assault charges. Moments later, competency concerns suddenly surface, forcing the judge to order evaluations instead. The entire hearing becomes tense and unpredictable.
I don't know if I'll be doing something.
You're on.
He's in Zoom?
Yeah.
Okay. Court does call the case People versus Orby Huffman.
Your children's apparently.
Your name, sir?
Orby Byron Huffman.
All right. And Mr. Huffman, you're intending upon representing yourself?
Yeah,
I'm sorry, you said what?
yes,
All right. I do have to again apprise you that you are before the court on the charge of assault of a prison employee. You understand that charge?
Yes, I do.
That is a felony punishable by up to 5 years incarceration, a $2,500 fine plus court costs. You understand that, sir?
Yeah, I hear you.
You understand that there are difficulties when you are representing yourself, but I need you to be apprised that the court will treat you the same, as you won't receive any worse treatment, you won't receive any better treatment. You understand that?
Yes, I do.
And you also understand that the court will presume that you have knowledge of court procedure and court rules. You understand that? The court will not be in a position to assist you regarding any of that. You understand that, sir?
Yes, I do.
Do you still intend upon representing yourself?
Yes, I do.
I do have to also tell you that if at any time you change your mind and you wish to be represented by counsel, you just need to inform the court, and the court will ensure that counsel is appointed to represent you. You understand that?
Yes, I do.
All right. What are we doing on this case?
I would indicate, I've just been informed by several of my colleagues that Mr. Orby was, or Judge Conlon yesterday on a case where he's represented by David Burgess, referred for a competency evaluation.
Oh, he was referred for a competency in that case? All right. Given that, would the people be requesting that I refer for competency on this case?
Because at this point, there's a question with respect to his competency, and we need to know that he is in fact competent before we vote.
Mr. Huffman, anything you want to say regarding that?
I cannot hear what he said.
What he indicated is that you were before Judge Conlon, that you were referred for competency on that case. And that then a hearing was set. I then asked whether or not the people would also be requesting, given that information, that you be referred for competency on this case to make sure that we can proceed forward. The people have made that request. I then asked whether or not you had a response to that.
I feel like I'm capable of representing myself.
All right, thank you. Given the information that has been provided regarding a competency evaluation, the court will order on people's request a competency hearing, a forensic evaluation. I'll set a competency hearing for July 2nd, 2026, 9 a.m. And Mr. Childers, I will need an order. All right. Bond will continue. Thank you, Mr. Hoffman.
What is bond?
I'm sorry?
What is my bond?
Your bond in this case, as set, is $50,000 cash surety.
Is that 10%?
No, it is cash surety.
Thank you.
Thank you.
Around 12 minutes in, the courtroom atmosphere turns uncomfortable when Jason Bryant returns to jail for more plea discussions before Orby Huffman insists on representing himself against felony assault charges. Moments later, competency concerns suddenly surface, forcing the judge to order evaluations instead. The entire hearing becomes tense and unpredictable.